I speak slowly and distinctly because the tape computer backup that records the sounds that we're making is not functioning. She's skilled. She will take what comes in her ears and put it onto her transcription machine and make a record. So, like spelling your name, you have to spell it slowly. It's just stuff like that. So this is a meeting of the Cambridge Planning Board, and the first item of business is an update from Brian Murphy. Thank you. So we are going to now discuss Planning Board Case 288, 40 Thorndike Street. As most of you know, we have had several meetings on this subject. And the most recent meeting was on the 29th of July. And at that meeting, some additional information was furnished to us, some changes to the design. We received a great deal of public testimony. This is my public testimony binder clip. And it has probably 300 pages of paper in it. But at that meeting, the board did not have a chance to deliberate. We listened to you, we made some brief comments, but we did not deliberate. That's the purpose of this meeting. We have not received any new information from the proponents. We've received information which I will confirm with my colleagues that is sufficient for us to deliberate and try to reach a decision. So we're not anticipating soliciting public comment at this meeting. Just pointing it out. I'm trying to, but it seems maybe I have to hold it differently. So we don't anticipate opening up the meeting to further public testimony. We may ask questions of the proponent if there are questions of fact that we need to find. Again, we've got hundreds of pages of information for everybody, and so we may see that. So that's the plan for the evening. And my colleagues agree with that plan. The staff on the 23rd of July gave us a memorandum, a project review memorandum, and we're going to try to follow that memorandum because it's essentially laid out all of the issues before us, the permits, the criteria. Liza, I think, do you have extra copies of that for the public?
So there's piles of the materials on the table right by the door.
Actually, just one left.
Oh, sorry.
Okay, so if you want to follow along with us, it's the July 23rd, 2014 memo. Late breaking news, like Ted reminds me, the city solicitor sent us an opinion at 2 o'clock this afternoon. Were copies of that out there too?
Yes.
Yeah. Which basically reaffirmed her previous opinion on the case that we, and I think that's actually the first item on this sheet here is to deal with the question of the alteration of the non-conforming structure. The city solicitor's opinion is that the courthouse is a lawfully non-conforming structure. And so I believe, are we agreed that that's our baseline? So then we would be applying the standard for the alteration permit, which affects some of the work that's going on at the courthouse. And that standard is that we have to find that the proposed changes are not more detrimental than the existing building. The solicitor clarified one point for me when talking about the existing building. The one that she feels we should think about is the most recent uses when the building was used, which is as a courthouse and a jail. So that's the point of comparison. So one way of trying to look at that question would be actually to go through the list of Chapter 19, Environmental Urban Design Objectives. That's a long list. We're going to have to go through it anyway. Does anyone want to help me out here with a suggestion as to how we might address this first question of how we make a finding of whether it is or is not detrimental? I mean, I have my own ideas, but this is a board. There's a button on here that should be green.
Ours is different.
Great.
Mr. Chairman, it seems that first we could make the decision just under section 8.22 under the alteration rules and the change, and even there, it seems to me that the changes that are being made are changes in structure, and I'm thinking that the question is whether the changes in the structure are substantially more detrimentally to the neighborhood than the existing structure, and if that's right, that doesn't in and of itself seem like a terribly difficult challenge. So I'm not sure. Is it? My read is that it's the change in the structure that we're looking at, and not the change in the use, because the use was legal and is legal, and the use that it's being changed to is legal. So I think it's just the change of the non-conforming structure that we look at under 8.22. Does anybody else?
Let's see if I can make this one work. That's my understanding as well, Steve, that we need to make a finding that the changes do not exacerbate the existing nonconformities that are there. That's the concern of the ordinance, as I understand it, in this section, which is, okay, you're going to change it. Are you going to make it worse? And I think we could discuss that quickly and come to a conclusion.
I think so, and then the more interesting and challenging question, I think, then would be under Article 19, project review, as a separate matter, after we've addressed the first question.
I'm just wanting to look for a moment at the language. So in 822, it says, permits for the change, extension, alteration of a pre-existing non-conforming structure or use may be granted as permitted in section 822.2 below. 822.1 doesn't apply. So I think then in 822, it says the following changes, extensions, or alterations in a structure or use may be granted by the following in the following cases after an issue of a special permit if the permit granting authority finds that such change, extension, or alteration will not be substantially more detrimental to the neighborhood than the existing non-conforming use. So I think use has to be part of the.
I think the reference, the operative word is non-conforming. If the original use was non-conforming, then the change of use would be subject to that review. But the original use was conforming. It's only the structure that was non-conforming. It's a little bit ambiguous in the drafting, but I think that makes sense. That it's since it's only the structure which was non-conforming in height and FAR, that it's only that change that we're looking at under that section. The change of use, were not for the non-conforming structure, the change of use wouldn't even be subject to this section. The change of use would not require a permit.
Correct.
And just to be clear, it's just the FAR that was non-conforming previously, is that correct?
Yeah.
Yeah.
Because previously there were a few other restrictions on them in business B districts. I mean, in a way, it's not, to my mind, terribly important because the uses aren't very different. Yes, the jail is different, but it was a big building with people sitting at desks working. Sometimes they were in conference rooms. They would be called courtrooms. In the courthouse, they'd be called conference rooms. But many features of the use were basically very similar. So
They'll simply allow egress and ingress in the housing units in the new development, unlike the old one. So there are 24 units, right? I guess that's the way the use changes in terms of the housing. But, there's a smaller population, I understand, because the units will be more commodious, I imagine, than what the previous tenants enjoyed. But it is 24 units, and we can compare that to the comings and goings of prisoners that were described in previous hearings, which were significant both for court proceedings and for the actual operation of the jail. So I would say if you split the finding, one on the dimensional change, obviously the building is being, as proposed, is smaller. It's being reduced in height. So I don't think that dimensionally we have an issue here in terms of a greater exacerbation of its current condition. The FAR is coming down. Relative to use, I would concur with the chair's comments that the use is analogous except for the housing, and I believe that the housing at 24 units probably will create less traffic and less of an issue than the prisoners' comings and goings did.
Well, I concur that the use is not really an issue. It was a court. People came for trials. Lawyers came all the time. There was also the DA's office, which had its entire Middlesex, I'm not sure the entire office, but a substantial office use there. There was a library that was used by the public, and then there was the prison on top. I think the residential use we will get to in a different manner, because we have to determine under the ordinance that a building not built for residential use can be used for residential use. I've been struggling with is to see if there was any way you could come into the back door to talk about use. And the only possible way I could think of it, and not very successfully, was to say, well, even though office use was allowed and is allowed, we would not have allowed, or planning board would not have allowed, such a large building to house so many people making part of that use. But I still think that is backwards, and that we have to deal with the fact that the building is there, that it had a allowed use before, and it will have an allowed use now, and that I think really what we're talking about is the dimensional changes.
So I'm going to take a small issue. I looked at the 1970 ordinance, which was the ordinance that was, the building was not permitted by the city. Did not get any zoning approval. As far as I know, it didn't get a building permit. That was the way the county and the state acted at that point in time. As it was reviewed by the Department of Public Safety. There wasn't a state building code at the time. But when I looked at the ordinance, there was no category for municipal or state or county uses in the ordinance table. They simply weren't there. I assume the reason they're not there is because we can't regulate them. I don't think it changes your argument, but just as a matter of fact, if you go to that table there, you won't find the word courthouse.
Well, no, I haven't looked at the earlier ordinance, but I think, well, if don't necessarily want to go there, but that brings it even closer to the Durkin argument that you had a use that was not even in the ordinance, and it was there simply because of governmental immunity. And I'm sorry, that you had a use that was there simply because it was governmental immunity, and then that brings it back into the Durkin case, talking about the federal post office, that regardless of how it got there, it was a legal non-conforming use, and now we have a proposed use that is allowed under the ordinance, and in fact the courthouse use is now allowed under our existing ordinance. So at some point in time, that use, courthouse use, which may not have been named, was named and became a legal use, and we're talking about another allowed use.
So are there more comments on the question of the detriment, question of is the structure with the alterations more detrimental than the existing building? I guess I would comment, and I'm not sure this is the right approach to the standard, which is there are many detrimental things about the existing building that are being fixed. Just in general, the way in which it meets the street and the sidewalk is changing. The scale of the lower parts of the building are being changed significantly. The open space around, of which clearly that's a detriment to the building. There is no open space today. There is open space being provided. So the detrimental aspects of the existing building are being reduced in the new proposal. I think we could come up with a longer list of things that we could add to that if we wanted to.
Just to build on that comment, Hugh, I think it's worth acknowledging that some of the impacts of the structure that have been addressed through these hearings, such as shadow and wind, are not significantly being improved, but are also not more detrimental. And in fact, through the course of these hearings, the proponent, in fact, did extensive studies and made some changes to the cladding of the building they were proposing to ensure that, in particular, the wind was not made more detrimental than the existing surface. And it's, again, not to say that it's getting better. It's, there are some efforts being made which may or may not be successful, which we certainly hope they are. But I think we can say that with respect to shadow and wind in particular, which were brought up repeatedly, that the proposed building is not substantially more detrimental.
The only thing I would add briefly for the benefit of the audience is to please understand what we're doing and what our constraints are here. I mean, nobody on this board is saying that we think this is an ideal building in this location. And there may even be some who feel that it should be changed if we had the power to do so. Perhaps there are some who feel that way. But we're really constrained to apply the law and the zoning ordinance as written. And I think we're all understanding it the same here. And in order to apply this law with some degree of integrity, the critical question are the changes in the structure substantially more detrimental to the neighborhood than the existing structure? And I think some of this discussion, or at least some of the members of the board right now are saying, no, the changes in the structure themselves are not substantially more detrimental to the neighborhood, and in many respects are more advantageous and beneficial for the neighborhood, which is not to say this is the way we would have designed it and approved it on day one. But that's not the question. The question is simply, is it more detrimental than the existing structure? I just wanted to explain that.
That sounded pretty close to a motion on a finding on this matter to me, but I'm not the chair and won't cut off the conversation. But this is a fairly narrow point of discussion. There's going to be much richer, and I suspect some points of disagreement as we get into Article 19.
Well, I just wanted to follow up that on this issue that, I've been spending so much time walking and driving around the courthouse that I think the police think I'm some sort of building stalker. And I mean, there's no question that it's a huge building that looms over the entire neighborhood, and that is certainly different, dramatically different from everything else that is around it, and is not, I'm sure, what any of us on this board or some prior board would have wanted to have seen there. But having said that, if you look at the building that's there now, it's really pretty unattractive. That the podium is just fortress-like. It is cutting off all the streets that surround it, all the neighborhood that surrounds it. The building is tall. It's sheathed in concrete in a brutalist style that was a style of that era. Some people still like, but has nothing to do with the rest of the neighborhood. And so, when I look at that, and then when I look at what is proposed, I think the exterior changes to the podium, the exterior changes to the building, and the removal of 2 floors certainly can't be said to be substantially more detrimental than what's there. And I did want to point out that Section 822(1) lists certain things that can be done without any special permit, and that includes construction occurring entirely within the structure, including structural changes, providing that there's no increase or of existing or creation of a new violation, and similarly demolition of a structure or portions of a structure that reduces the extent of existing nonconformity. So when I look at those things, and when I look at the difference between what is proposed and what's there, just under this section of the ordinance, I come out that it is not, I would find it very hard to say substantially more detrimental than the existing structure.
Is there more to say on this? So that would, if we would make that finding then. Okay. Moving along to the next item, which is in the memo now on page 2, conversion of non-residential structured residential use, section 5.28.2. So the purpose of this special permit is to allow to reuse buildings that may be out of compliance with the current dimensional requirements, especially when they are converted to residential use. And the criterion: the board shall evaluate the impact on residential neighbors of the new housing use and any other proposed use as it may affect privacy. And then there's a list of things like windows, screening elements, decks, security, and other lighting, other aspects of the design should be reviewed in order to ensure that maintenance of reasonable level of privacy for the abutters. The board shall consider, among other factors, potential negative impacts of the new activity on abutters as a result of the location, orientation, and use of the structure in its yards as proposed. We mostly have seen this in the conversion of school buildings, generally historic structures, into housing, although there are some other examples of converting factories. And in most of those cases, the neighbors are 20 feet away or 30 feet away. So I think my first thought about this is that because the residential abutters across Spring Street are, across the street, and the height of the residences at 4 stories is not significantly greater than is permitted, that the privacy is not going to be affected. I think I am concerned about what people have called the lantern effect. And at some point in this proceeding, I would want to propose a condition that would require the design of the lighting in the tower, inside the tower, to be such that the lights themselves, the lamps, and the primary reflecting surfaces that in the fixture, thanks to Mr. Teague for this knowledge, would not be visible beyond the street line around the building. And I think I'm a little sensitive to this because I live 40 feet to 30 feet from a public school. And when somebody leaves a classroom light on all night, it's very noticeable. It's somehow, I mean, I know there's nobody up there in the classrooms, it's just left it off. Or if there is, it's just a janitor, and I do have my blinds closed anyway. But in a way, it's sort of a privacy issue. I think that, again, we got education from Mr. Teague's proposal on controlling light spill, about how people feel about that. So I'm not sure this is the right place to insert that condition, because it also is an environmental impact under the Chapter 19 review. And I'm not sure you agree with me either.
No, I agree. I think we should get to that and put some conditions, should we get through Article 19 tonight. I was going to comment also on the privacy, just to point out that the two proposals that I saw during the course of our deliberations seem to go address that concern directly, particularly the revision of the facades of the building. As you recall, the first proposal was for an all-glass building, which would have not only been an issue with the lantern, but also the new cladding, the new systems seem to address light and views and begin to address the issue of privacy very directly, I believe, in the new design.
I also agree that we should address the lantern effect. I don't think this is the right place for it, because the testimony I've heard speaks primarily to the phenomenon you were speaking about, where lights are left on and either no one's there or it's late at night and inappropriate. It isn't about someone in their home turning on the light in the kitchen at 11 o'clock at night. And not to say that we shouldn't have that same language about the lamp and the reflective surfaces apply. They shouldn't be visible from beyond the street line. But this particular special permit criteria talks about the impact of the new housing on privacy. And that lantern effect, even though I agree it's a real concern and needs to be addressed, I don't think is so much a concern that is created by the creation of new housing in this non-residential use.
Relative to the issue of privacy, I do remember testimony from a gentleman who came out a couple of nights, I believe he's here tonight as well, to address the issue of acoustics and acoustical privacy and the effect of the jail on his quality of life in the community. I believe that this change of use and the tower and the assertion that mechanical systems will be in compliance with the noise ordinance will go a long way to improving the sense of privacy and the sense of noise that has historically been emanating from this site. So I think there has also been a huge amount of improvement over the existing conditions relative to the acoustical privacy that neighbors might have.
Yeah, there was in the original submission, I guess dated almost a year ago, there was an acoustical report that looked at the sound levels that would be obtained adjacent to the building, and there was a reduction of somewhere between 2 and 5 decibels. And there was a commentary that said some of this was due to the mechanical systems actually down at grade, more than the ones up on the roof, but there would be improvements up on the roof. So in terms of, that's I think something we need to credit and give credit for.
While we're talking about the conversion to housing, I also note that this requires that we consider the efforts of the applicant to solicit input from affected neighbors and submit a report on that solicitation of input. And while certainly the applicant has been engaged in many conversations and has received a multitude of comments and input and have provided us a report with all that has on. The requirement here isn't that any unanimity be reached with the affected neighbors, it's that they solicit the input and tell us about it, and we have to make a determination as to whether or not that's reasonable. They've made reasonable efforts, and again, it's only with respect to the conversion of the housing that finding applies. For my part, just to be clear, I think that finding can be made with respect to conversion of housing.
And I would agree. It's, in a way, we might be useful for our discussion about planning board process to actually get some kind of chronology of all the public meetings that have occurred on this project, and because I don't think there've been too many. I think there've been enough to solicit public opinion, but when we think of altering our rules to require the meetings, we've got to find a way to figure out how much is enough. And so a more comment on 528, the conversion question.
Mr. Chair, I just had a couple of comments simply because we are talking about housing here. And I will grant in advance that I think my comments may be more appropriate as we get into the Article 19 discussion. But I would simply say that for this project in general, for much of what we do, and certainly under the project review standards, it's to some extent a balancing act. I mean, no project is absolutely perfect, and every project has some detriments, and part of what we look at is to what extent are they mitigated, and to what extent are there benefits which balance or outweigh the detriments. And one of the things that strikes me, since we are talking about converting to residential, is that one of the benefits offered to the community here is the affordable housing. Maybe I'm just setting the table for a discussion, as I say, under Article 19, but it does strike me that as we evaluate the benefits and the detriments, that something that strikes me is that I wish there were more affordable housing and maybe even moderate income housing here. And when I'm talking about something which exceeds the requirements of the ordinance, which I think obviously is the minimal base. That's not negotiable. But again, when we get into the Article 19, we are weighing, evaluating benefits and detriments, and I'd like to get into that discussion for what more we can do in the residential portion of this project to grant a benefit to the community and to outweigh some of the detriments of this project. Having said that, I have no problem with the conversion of non-residential to residential.
So on page 3, there are 3 things we need to evaluate when there are more than 10 dwelling units. More than 10 dwelling units. One is we have to evaluate parking, and there needs to have been a report submitted in the parking analysis. In this case, they're proposing 1 dedicated parking space for each dwelling unit located in the building in the upper basement level. So I think that we could easily find that they're providing parking which is, based on what we're learning, probably more than adequate. The second is the appropriateness of the proposed floor layouts for multifamily residential use, and with attention to the typical range of unit sizes and types that would be expected for housing in the neighborhood. And what this, I think, is getting at is that non-residential buildings converted to residential use may not have ideal dimensions. And this is one such building. So if you look at the plan of the residential units, you find that there are, at the corners of the building, there are very relatively conventional two-bedroom residential units. In between them are very deep, smaller units, sort of studio, lofty units. So they've got a lot of space, but they don't have a lot of frontage. They have, sort of one set of windows. And so I think that's what's created the mix of sizes, which is probably not typical in the neighborhood, but it's simply, this is the way you can use this building for housing to maximum the amount of space in the building used for housing. And I think we need to say we recognize that this is what's happened, and that we think that due to the shape of the building, the somewhat unusual unit sizes make sense for this particular building. And then there's a third thing, if there are, that we could consider special kinds of occupancy for the dwelling units, which as an added factor, but I think in this case that's not being proposed, and I also don't think that given the small number of residential units involved, we're not mitigating the size of the residential use in this building. The residential units themselves are mitigating in using the space in the building, certainly the reverse from the usual thing of developers trying to put as many units as they can into an old school building. So, have we made the findings we need to on this?
Mr. Chair,
I just wanted to add a couple of points. I personally would prefer a different mix of units. We've been getting some 3-bedroom units in a lot of the new projects we've been seeing, which we've been advocating for a long time. It's obviously a juggling act between how many units you end up with total and the size of the units. That may come up again in section 19, but I did want to point out that having a residential component of this building is in keeping with the East Cambridge design guidelines, which sees a mix of retail, residential, office use, and the fact that we can get this all in one building, I think the residential use will help to enliven the streetscape, will take away certainly from the fortress aspect of the current building. Those units in the podium are much more in keeping with the size of the residences around the building. And so I think having residential use in this building is a positive aspect of the redesign.
Are there more comments? Do people feel we've covered the findings we need to make? Okay. Isn't this fun? So the next section would be the urban design review. And the first part of that review is in the ordinance is the traffic review. The pages 4 and 5 are kind of general comments by the staff, and then you get into page 7, you get into the criteria. So we're going to have to probably come back to look at pages 4 and 5 as we go through the list.
So let's start with transportation.
Let's start with transportation. The planning board shall grant the special permit only if it finds the project will have no substantial adverse impact on city traffic within the study area as analyzed in the traffic study. And we have a report from the Traffic and Parking Department and an update to that report that was based on the reduction of the floor area by taking off 2 floors in July. To my mind, there are 2 important things in this report. The first is where most of the cars coming to this building are going to be parking. And the answer is if they'll probably be parking in the First Street garage. If the city doesn't get that, then they would be parking in the Galleria garage. Both of those garages are entered on First Street, and the First Street, particularly once we get the North Point process done and First Street connects more felicitously to O'Brien Highway, that's going to be a lot of the connection to the regional system is going to be in that way. If they're going westbound, then they would go onto the Memorial Drive or something again. First Street is the better route. So there's not much incentive for traffic to try to wander through the numbered streets in the neighborhood, and you couldn't ask for a better place to put parking. So that's sort of the overall thing. The other thing is there are a number of criteria that were studied in the traffic study, and none of the automobile-oriented criteria exceeded the criteria that we applied to the study. And there were a few exceedances in the pedestrian level of service, and there's some conditions in the suggested by the Parking and Traffic Department to try to mitigate those or fix those. Some of them can't be fixed. One of the intersections that was studied was the O'Brien Highway Gilmore Bridge intersection, which has pedestrians have to wait a while there because of all the phases, I believe, and the distances involved. And that's not something this project is going to be asked to fix, and I'm not sure there is a fix. So, to me, that's the background. We have a report. It's been certified as being a proper report. We have recommendations from the Traffic and Parking Department that show that they agree with the way in which the report was done and in the amount of parking that's being provided or should be required to be provided, which is sort of in the middle range between the minimum and maximum of these uses. So that's the way I would approach this.
On this issue, I concur with your summary of the background. What interested me was the ways in which future transportation modes were being anticipated by the project. We're seeing at the planning board, we're seeing in our own personal experience, all of us, that preferred modes of transportation in the city of Cambridge, in fact, in many parts of our country, are changing really quickly. Bicycles are becoming way more prevalent. Pedestrians and public transportation are also pedestrian use and public transportation are being used much more dramatically. And we should articulate, I think, for the record, the ways in which this proposal anticipates, for instance, bicycle use, supporting hubway, etc. So it may be worth just going through that narrative as we understand it.
So you added hubway there, and hubway is a condition of the traffic department that we want to add to a decision. Should we decide that we're going to grant the permits? We should note that they have provision for bicycles is in conformance with the ordinance. There's a large bicycle room at the upper basement level, which I think is more or less at grade at that corner of the building. So it's a pretty easy way for the bicycles to get into the building. I believe there are shower and changing rooms adjacent to that facility. Are there things people want to add to the list of transportation?
I think it's worth noting that the transportation study does not give any credit per se for the use which has vacated the building. That is to say, it's not a measure of how much better or worse it was than the building when fully occupied by the courthouse and jail. It is an evaluation of the traffic created from this building as though it was starting from scratch. And so when we say there are no exceedances for vehicular traffic and everything, that's not some discounted number they get because there used to be a use there. With all of the conditions that traffic and parking outlined, and that includes the full PTDM plan, the TDM plan for the residences, the Silver Hubway membership, the Hubway station, the Easy Ride stop, the various pavement markings and infrastructure that they've detailed, and traffic studies, as well as the bicycle repair station and electric vehicle charging station. I think those are all very good and important things to make the finding that it will have no substantial adverse impact on transportation, but it should be noted that just on its own, without doing any of these things, the vehicular traffic already meets that, and it's not because there was some discount for the existing traffic.
Well, the conditions I think we should consider amending to, should we grant the special permit, because they're I believe them to be forward-thinking and further can ameliorate any traffic that may be coming and going, no matter at what level, from this building. So I think we're all in agreement that the recommendations should perhaps be made a condition. I'm putting words in fellow board members' mouths here, but I think that's my sense anyway of the way the flow of the discussion is going here.
Right, and I was keeping track of Catherine, and she hit all of the numbered items in summary, but not in the full detail that the department has recommended to us. That's the full detail we're interested in.
I guess my only concern is, given the fact that the T-station is going to be moved and that we've got the various parking lots in the area, whether we need to make sure in our conditions that traffic and parking will have some flexibility. I mean, if they were to ultimately decide that having a Hubway station at this particular location is not the best place to have it, but perhaps it should be a block or two away or in some different location, that the condition would be that the developer has to do, what the traffic and parking reasonably requires of them with regard to the Hubway station or with regards to some of the other elements of the TDM.
So I'm asking Sue Clippinger, have you already done that determination?
Yes.
So Sue's saying yes, she thinks she wants a Hubway station here. What happens, when bicycle sharing services for some reason are superseded and we have these lingering conditions? Are they written in such a way that everybody's not going to come back? I mean, it's a pretty common condition. I don't know. That's just something for the lawyers to think about. There's plenty of lawyers on both sides of this table.
You might want to call it bike share.
Right.
Rather than the brand name.
Because that concept is much more likely to be available in various different forms.
I believe that's how it's written in the PDA.
Okay.
Please repeat the comments. We can't hear them.
The comment was that the PTDM plan has the Hubway station identified as bike share rather than as Hubway. So it's the, okay, have we done transportation? Okay, now we get to do the building review. So I looked at there's a list of objectives, and the language of the ordinance basically says we should consider all of these things and others if they're relevant. And if they are relevant, we should see that the petitioner has taken the steps necessary to minimize the, what's the exact wording? Did you have that still open? In other words, the criterion is not that you've got to do everything on the list. The criterion is you've got to do the best that you can in addressing the issues that are identified on the list.
Mr. Chair, I can read that if you like.
Sure.
It would tell me if I'm on the wrong page. The project need not meet all the objectives of this section 19.30, where this section serves as the basis for issuance of a special permit. Rather, the permit granting authority shall find that on balance, the objectives of the city are being served. Is that it?
Perfect. So I'm looking now page 9 of the city handout because it's got a chart of urban design objectives and criteria. And maybe, so the first criterion is new projects will be responsive to the existing or anticipated pattern of development. And it seems to me the things it does that are applicable, it's by the redesign of the podium. It is much more consistent with the established streetscape. It has some retail on the ground. It has some residential above on the 3rd Street side and wrapping around the corners and spring out to Thorndike Street. And that the uses are compatible with the adjacent uses. I'm not, on the consideration of nearby historic buildings.
Speak to that.
Sure, I'll remind you that Graham Hunt came and said that he didn't like the building.
Indeed, and what we're looking at is what's being proposed, what do they want to do now? And what we're doing now is we're, I think, softening the edge of that building that faces the historic buildings. And I think it's compatible with consideration of nearby historic buildings.
Well, certainly the emphasis on terracotta, so that there's a earth-based material that the building will be cladded in rather than the reinforced concrete, which I think is more consistent with the former courthouse building where I happen to be married. I'm very fond of that building. So, but I don't have the same relationship that Graham Gunn did to it, obviously. But this is one where if you just take the comments flatly, it doesn't seem to make sense that we're making this finding. But again, I think I go back to Steve's speech at the beginning of this, saying none of us would propose this scale of tower behind that historic courthouse today. However, it's there. So what has the proponent done to realize and recognize its condition next to this historic fabric? And I think that the careful choice of materials which are compatible with that landscape and the landscape and the streetscape are beginning to acknowledge the importance of its historic neighbors, notwithstanding the height and bulk of the building, which is extant.
Other comments on this? Next is development shall be pedestrian and bicycle friendly with a positive relationship to its surrounding. And in this case, I think all of the considerations are met in this proposal. It has inhabited ground floor spaces, does not have ground floor parking, has windows on the ground floor, has its entries are on the streets, and has a safe and convenient bicycle and pedestrian access. Some of the conditions of the transportation department are intended to improve the pedestrian access and the safety issues. Again, it's a lot of this is accomplished by the podium. Essentially, all of these things are accomplished by the way in which they've transformed the podium, proposed to transform the podium.
Mr. Chair, I'd like to add that one of the conditions is the ground floor should generally be 25 to 50% transparent. The greatest amounts of glass would be expected for retail users with lesser amounts for residential use. And I believe that we're there on that.
Yeah, it's probably over 50% because of the retail use and the generous kind of windows in the storefront. Next, we consider building and site design should mitigate adverse environmental impacts of a development upon its neighbors. And so I think they've worked hard to locate and screen mechanical equipment. The loading facility is on 2nd Street, facing the public garage. And it's also got doors. It's interior. That's the best place, I think, on this block to have that. I think that's something that in the final development of the architecture there is something that we would want that to be continually reviewed to see that is it very detailed treatment. And so see Suzanne is writing that down. That's something we would hope you would keep in mind as you look at the final plans. Stormwater management, they are essentially required by Public Works to do this, and what they are doing is installing a tank that will collect stormwater and presumably allow it to be put into the system at a later time. They have a more permeable area than the previous building, which had none. Next criteria is shadow impacts. There's only the slightest change because of it moving 2 stories. Retaining walls. I think in this case, there are, because of the changing grades that go around the building, there are places where walls exist, but they're being looked at very carefully in the landscape. Right now, the retaining walls are kind of right out on the sidewalk. And in the proposed design, they're, particularly on Spring Street, they're back, buffered by the landscape. There aren't retaining walls. I think there are no retaining walls on Thorndike and 2nd Street. And they've been adjusting the grades of the shops and the floor grades in the building so as to bring the retail uses so they more closely abut the grade so that you don't need walls. Building scale and wall treatment, that's probably something Tom wants to weigh in or already has.
Well, in this case, meeting the urban design objectives, the walls are long, but there has been an attempt to break down the scale of these walls to deal with the inherent architectural condition of those walls. Also, the celebration of the entrances begin to break down the scale of that wall to begin to make it more consistent with the pattern, shape, and scale of the adjoining neighborhoods. Again, we're focused almost entirely on the podium here, Hugh, so the discussion needs to be seen within that context. We're stuck with the tower, and the tower itself, in terms of dealing with its building scale. Again, I would compare it to the easiest way to understand what the architect, I think, is trying to do here is to compare it to the first proposal, which was the lantern, the sheer glass box that we initially saw. The revised elevations go a long way to breaking up the scale of that wall and offering visual delight as to the extent you can on a building that dimension with smaller components.
Right, and some of the ways it does that on the tower is sort of establishing a 2-story banding so that as you sort of unconsciously count the floors, it's there are 7 bands of windows, which actually I think encompass 15 floors, but it's a way of giving some scale to something that in the previous scheme was featureless and in the existing building is very monotonous, except for the wards. And I think also the treatment of the wards, these are the slight projections beyond the building that presently are almost windowless and have something to do with the courtrooms, I believe. I think they're aware that courtrooms occur. And the new treatment somehow is able to pull those in and connect them to the rest of the building through the use of materials. Outdoor lighting. I couldn't find anything on outdoor lighting in the proposal. Is it that? I don't believe they've gotten to that level of detail.
Hugh?
Yes.
I think I might suggest that this is where we might address the lantern effect, because that it would qualify as an adverse environmental impact of the development upon its neighbors. So while this particular bullet probably was envisioning outdoor lighting as the kind of lighting installed outdoors, I would use this opportunity to speak to how the indoor lighting illuminates the outdoors and the abutting properties, and say that this is probably where we would include any condition on that.
So I think we all seem to be in agreement with that. I don't want to lose the outdoor lighting plan, because I think that's something that needs to be reviewed, and if it's not ready to be reviewed now, then it has to be put in a condition that it be reviewed at a later date. It's perfectly possible to do a good job. It's just it may not be shown currently.
Right, and I guess some of the concerns of the planning board relative to outdoor lighting, just to give some direction for future discussion, would be obviously light spillage off the site. There's an environmental concern of light spillage into the night sky, so the lumens have to be focused downward. And then there's the overall brightness and reflectance off those surfaces, which needs to be considered in that design.
Also, I assume the Spring Street open space should be lit probably 24 hours a day, but maybe at different intensities at different times of night. But still, I think it doesn't want to be a forbidding place there. So, it has to be designed appropriately. And I'm sort of footnoting. I don't want to use that. Yes.
I think this is the first item that we've run into where we've said it is subject to review later, and I'm just wondering if each time we run into such an item, whether we should think about whether it needs to be reviewed and approved by this board or by staff. By staff.
I mean, that's what staff normally does.
I just want to clarify and confirm that. I would certainly support that. And we're talking here about both the outdoor lighting and the internal lighting and the lantern effect.
Right. I think the lantern, how they choose to address the minimizing of the lantern effect, I think is something that probably needs a kind of lighting consultant, a report. That report can be reviewed by the staff, and there can be a dialogue set up around that. It's all technically possible. If we didn't think something was technically possible, then I think we would have a problem. If we think it can be done, and it's just how it's done is the issue, then I think we can leave it to the staff review.
Yeah, it's worth pausing on this because I think fellow board members are right to raise this. They were looking for something extraordinary here. I mean, this is not business as usual, and they had a lighting consultant come in here and begin to try to explain the way in which all the geometry of these lights were going to work, and there was a lot of questions that were, as I recall, not satisfactorily answered given the geometry, and some really good questions and concerns raised by citizens about that lighting work. So I just want to emphasize how important this is for review at the staff level, to be very sure that we're looking for an extraordinary, perhaps unprecedented solution to this issue because of the height and bulk of this building and its site within the residential community.
Yeah, I noted in that report the consultant had placed the lighting as ceiling troffers, which in a way is, I mean, in one way it's good because it's giving the worst condition. You know, if you're in your house on Spring Street, you can look up through the windows and see hundreds of light fixtures directly, just because you can see the ceiling of many floors, and you know, you see the first row at least. That's what we want to avoid.
Hugh, do you know, when we're talking about lighting, given the somewhat reduced height of the building, will it still require the blinking red lights on the roof?
I'm seeing an affirmative nod from the owner's representatives, so I think we would say that it's our understanding they would still be required. I think the other bullet here is tree protection. My understanding is there are a few trees on the site in planters that are really awful. The trees are fine, but you can't get to them. So all the existing trees are going to be taken down, and a number of new trees are going to be planted. So I don't think there's a tree protection plan, but there's a tree replacement plan. And the trees are part of the wind mitigation. They're going to select the trees so they are species that don't drop their leaves in the fall, and so that the leaves help to reduce the wind at grade level. Now, this actually leads into the...
Mr. Chair,
Yeah.
I did want to make a comment before we go to the comment. And this comment really could have been made with the built form environmental guidelines as well, but I do want to say that there are environmental mitigations and conditions that are in this building that are very, very important and very critical, and that is that the asbestos is going to be removed, mitigated, taken out, that the building will be built with modern day energy efficient everything, and that I think is using less power, using less energy. The water efficiency and the sewer efficiency measures are also important in terms of water conservation, and the transportation demand management measures, which are important to this project, will help with atmospheric pollution.
I think there are a couple of impacts that aren't on the bullets that we need to discuss. One is the wind impacts. They've studied those. There's a report. I find it very difficult to see that report and say that everything that could be done has been done. I think that's the standard we want. Or every reasonable thing that could be done. I think the unreasonable thing is to take 15 stories off the building. That will make a big difference for wind. I don't think we're going to be requiring that the way we're heading. So I don't, I'm wondering, should there be more discussion about this with the staff? Does the staff need actually consulting help to help answer that?
Yeah, I agree, Hugh, but if I was listening to this, the comment, the criteria being everything done that's reasonable, the different reasonable people can disagree about what is reasonable as a solution. What I do recall about the wind analysis and the wind tunnel modeling that we saw was that the consultant came here and clearly there were some failing grades still revealed to us at this hearing in front of the public that this was a very windy place, and even with the mitigation, there were still some points that were not great. There was anecdotal evidence by a couple of neighbors who said they'd been blown over in the wintertime and under the existing conditions. And so this is a very serious issue in light of what we're considering here tonight. I think staff should get some professional advice so that there could be a good engineering rebuttal to the study, which apparently on its face had some holes in it, as I recall. So I would agree. I think we got to raise the bar on this environmental issue very, very directly, very deliberately.
So I would say, I agree. I guess if there is a question about what's reasonable and what's not, and the staff and the proponent cannot agree, then they can come back to us. I mean, that would be our task to weigh in on that. And I'm sure there will be some discussion, because I think we're saying this ought to be a condition, as to how to frame such a condition in a way that accomplishes what we're trying to accomplish without blowing the project out of the water from some investor's point of view. Again, I'm assuming that we're probably going to be, we seem to be into the mode of thinking about what has to be done if we approve this. And I think that's sort of in a way, it's what we have to do here. We may at the end of it decide by our vote that not enough can be done. It doesn't meet the standards. But I'm not going to presume at this point what the outcome is, but I think we have to proceed on the notion that there will be a motion to grant the permit, that the vote will be taken on it. And if there is such a motion, there are going to be all these conditions on it. Whatever conditions we come up with. Another thing that I think would be valuable, and I don't know where to put it, which is to have a construction phase committee of abutters and neighbors that works during the construction period to, and the model for this I would take to be the Cambridge Hospital expansion project, in which there was a committee that met for years until the project was complete, and was able to, I guess, address not only the construction phase impacts, but other things that became known during that period of time. I think we have to accept that there are going to be impacts during construction. There's heavy equipment, there's lots of things that are going on. And also there are people who are very worried about some of the potential impacts of abatement of the asbestos and the PCBs, to make sure that that is being done properly in accordance, so there's no danger to the public. And such a committee is sometimes helpful to dig into that question and help people and have a forum. So,
Thank you.
yeah.
Yeah, I would just say, first of all, we did the same thing with the library project. I'm glad you brought it up. As it happens, I chaired the Mid-Cambridge Neighborhood Conservation District Commission at that time.
I'm sorry, Cambridge, just,
Whoops.
yeah.
Mid-Cambridge Conservation District Commission. Neighborhood Conservation District.
Yes.
But it's, this isn't just a footnote, it's a really important structure. It worked really well in mid-Cambridge. And this construction project is going to be even tougher than those because of the magnitude of the project and the proximity to the residential areas. So, yeah, it's essential.
Hugh, who appoints the members of such a committee?
Probably the person who knows the answer to that is our city manager, because he was as deputy city manager, he was the one who was in charge of implementing these projects. And I think you need an appointed committee, but I think the meetings need to be open so that, maybe public meetings that would be noticed in some way, so anybody who had a question would have a place to come.
One other thing I'd mention also, he was, I think for both of those projects, we created, the city and the developers created a website with the ongoing status and information and frequently asked questions and who to contact and so forth. And again, one of the most important things in this whole process is just to make sure that the neighbors know what's going on, knows what to expect, and when, knows who to call if they have questions or complaints. And the website was really helpful for them.
So I guess our condition has to be the nature that the proponent will cooperate and participate in such a committee. And I think we would leave it probably to the city staff to figure out how to panel that. Is it, a function of the East Cambridge planning team augmented by the Neighborhood Association of East Cambridge? Exactly how that works out. The goal is to get interested people that are willing to sit on this committee, be there. And in a way, I tie it to environmental impacts because it's trying to mitigate the unknown environmental impacts. There will be a construction management plan that the city reviews at the building department. So it's not like it's going to be ignored. But next item. Projects shall not overburden the city infrastructure services, including neighborhood roads, city water supply system, and sewer system. We have a traffic report that addresses and says that the project will not overburden neighborhood roads. I have the city's water department, Department of Public Works will independently review the project. There are substantial public infrastructure in the area, and the water conserving and stormwater management features of the building should reduce the impact on the city services from the prior use.
Overburdening of the neighborhood roads. I think on 2 occasions we were shown video, which is really powerful visually in the context of a hearing like this, of traffic stopped on local roads. And the question was made, I think rhetorically, but I want to address it. How could even one more car not be overburdening a traffic situation like this, where we were told we were observing cars backed up over blocks? And we saw that video as a board. We looked at and examined very closely the traffic study that was done by the city, which was summarized, I think, very well by you earlier in the hearing, Hugh, in terms of where the traffic would be flowing as it related to where the cars would be parking for this development. And I would also say that it's not insignificant that the conditions for the traffic study anticipate future modes of transportation, which will, in fact, lessen the burden on the adjacent streets. So we're not immune to the video. We saw the video, appreciate the perspective of the community, but there's ways in which we're weighing this in a fact-based rather than anecdotal way.
I think that video was 3rd Street,
Yeah.
because that's where there are long queues. And am I correct, I'm going to ask this to Sue Clippinger, that part of the goal of the reconstruction of the intersection between 1st Street and the reconstruction of O'Brien Highway as part of the North Point project is to try to get more traffic off of 3rd Street and onto 1st Street? I think you'll have to come up here and take the mic.
I'm going for the closest one. So, sorry. In terms of the connection, it's not on. It's on? So in the goal of the punch through, as we call it, at 1st Street directly to O'Brien, is specifically to provide that as a preferred access mode, between Kendall and these movements. We may not get a lot of traffic off of 3rd Street, but the goal would be not to have it continue to grow as projects such as this one come on board. So I think it will improve travel times for people who choose to use 1st Street, and so we should be able to move some people, but I want to be realistic that it's probably not going to be a nice quiet street with no traffic on it.
But we can then say that we do not believe this project will overburden neighborhood roads based on the facts that we've heard and recited. Another cartoon in the same general thing is we should note that the project has a very lengthy lead analysis. Are you looking for certification on a lead?
Our goal is gold.
Right, and gold is a level that is one step higher than we require at the moment, but probably is, again, forward thinking. Okay, next box is new construction should reinforce and enhance the complex urban aspects of Cambridge as it is developed historically. And that's quite a mouthful. So one could say, well, this isn't new construction, so we can forget about it. But it's doing several things that are in the bullets, which I think we should recognize. That it is a mixed-use development, including retail. It is providing space for startup companies in the podium area. This does bring up one question for me, which is, how are the retail tenants going to be selected, because I think there's a strong preference for certain types of retail uses that would be serving the neighborhood. As somebody said to me a few days ago, a place where you can take your kids, maybe meet some neighbors, maybe sit outside at a table. That it's the community building aspect of retail that is becoming more and more important. And it seems to me that this might be a subject that an advisory committee might look at and comment on, because I think that you don't rent retail space in general until it's ready. People who rent retail space don't believe that something might be done at a particular time very well. So particularly the smaller tenants, the more neighborhood servings, the non-chain people. The city has a number of efforts to support this kind of retail. I just got an email today about a whole series of things that the economic development section of the CD department does to support people who want to start businesses. But I think there needs to be continuing dialogue about this on an advisory basis, because it's pretty important. And I think I'm willing to have it be advisory, because I think the proponents are good listeners. They're making good listeners. They've listened to comments and responded where they can. And and I think until you actually have specific tenants and specific places, then you can't really have a discussion. And that's going to be long after we send this on.
Mr. Chair, we also saw that Kendall Square and the development there had terrific results using consultants whose job it was to assess the kind of retail that would be workable, and then to go seek it and bring it in. We can't always do what people want to do in a retail outlet because it's commercial, it's a business, and it runs by different rules. But I think that in Kendall Square we did get a lot of good retail by using somebody that was their profession, that's what they do, and maybe we could do this with the advisory committee as well.
Right, or we could require a plan be prepared that would indicate how the steps they're going to take, so that I don't know how to proceed, but I think it's important that I'd like to try to find some way to try to get the best outcome. And I'm not sure we can do it sitting here writing conditions.
So you're describing a kind of Jane Jacobs retail environment to the extent that we can, neighborhood-based, that belongs in the community, and I think that it's pretty clear what it is we're looking for. I appreciate the mechanisms that my fellow board member had suggested we might use, which is an extension of that, perhaps in that committee. I'm also not losing sight of the fact that retail is at the heart of this proposal, right? This proponent is proposing to try to get a grocery store here. So these guys seem to really be focused on that, and so that gives me some hope that they can achieve I think the really nuanced and important goals that you're articulating here.
Any more comments on the complex urban aspects of Cambridge? Next criterion is expansion of the inventory of housing in the city is encouraged.
Hugh, can I pick up on that since I
Sure.
approached that subject earlier? As Steve Winter pointed out earlier, that our review of all of these factors is do they comply with these urban design criteria on balance? And I think, look, there are some detriments. There will be impacts of this project. Are there other benefits that will lead us to believe on balance that it's advantageous? Contributions to the housing stock, diverse housing, is one of those factors that at least for me would persuade me to forgive other lesser detriments. I think you also said that on some of these factors, the way to look at it is to say that everything that can be done will be done. So far, we're looking at 24 units, and I think 4 are slated to be affordable. Unless I'm way off, I think this is probably a project in the neighborhood of $200 million. I don't think that what so far we're proposing, what we're hearing for affordable housing is all that can be done. And I guess with your permission, Mr. Chair, and forgive me, folks, if I can direct the question directly to you today. Can you do better on the housing? And just to throw out an idea, for discussion and for reaction, I would suggest, 1/3 affordable units, 1/3 moderate income units, 1/3 market rate units. Honestly, if I understand the economics of the building correctly, the residential economically is almost the tail of the dog here. Forgive me if I overstate that. But I think that's probably not far from the truth. And so I would be proposing to you folks that you provide that sort of commitment to the diverse and affordable housing stock of the city, and help us digest some of the other potential impacts on the city and the neighborhood. Mr. Chair, is it okay if the proponents respond?
And with I think one of the things people have talked about in the moderate is to.
Rob Dickey with Megan McCall Properties. So the answer to your question, Steve, is that we would definitely consider that. I think on the moderate side, giving neighborhood preference, I think would also be, which I think is a starting point, and then to the extent that a unit wasn't taken by somebody in the neighborhood, then it goes outside the neighborhood. But I think that's another way to get at a similar goal of yours. That has been something that's been asked of us in public meetings. I'm interested, though, in other people's thoughts in terms of the mix and whether it's the right mix, because I think on balance, it's important to have the right mix, and I think we're open to a mix of market, affordable, and moderate. And it's a third the right mix. I'm not sure.
Well, while everybody else is thinking about how to answer that, I certainly don't know what the right mix is. The symmetry I found appealing. That's as sophisticated as my analysis went.
Plus 24 is easily divisible by 3.
Well, I certainly don't know what the right mix is, but when you're considering the mix, I would really prefer a different mix of size of units. I think there's an overwhelming number of these, not even one bedroom, just sort of study loft units, which certainly would not be conducive to families. I envision those were intended for office workers who might work in this building or who might work in nearby buildings in Kendall Square or in North Point. But I would really prefer to see more too, and some 3-bedroom units in this, because then I think we're going to be promoting the family nature of the neighborhood.
On the next question, I've been involved in 30 housing projects in the last 40 years as an architect, often in projects with several architects. The advice I get from my clients is they like a kind of an equal mix between low, moderate, and market. One of the problems with the city's formula is that when someone goes out of one category and they get a raise and suddenly they don't qualify for low, they have to move, which is not a good thing. Whereas if there's a middle ground, it can work. There are 24 units in a city with 40 or 50,000 housing units. We're not going to change the tide of the city here. So I would support the notion of a third, and a third. As an architect, I look at the building and I think it's going to be very hard to do what Ted wants without losing usable space or doing things that you may not wish. I'm working on a mill building now for the last 25 years. Being bid for the 4th time this week. And a lot of the problem with building is that it's 92 feet thick. And it's got way too much middle for the outsides. And that's the problem of the space in this building. It's way too thick. And we've taken different approaches and different schemes over the years. And the current one has a lot of interior bedrooms, which, if you've got a 15-foot ceiling, which we have in the mill building, you can kind of say, well, okay, the light, huge windows, the light will get there, but it's not ideal. And so I think, what the architects have done here is try to use the space. Now, could they sneak one more bedroom into the innovation space and convert some of the 2 bedrooms to 3 bedrooms? That's something they might be able to do. I wouldn't like to lose units. I wouldn't like that. And the other thing is that, there are a lot of, I have another client who provides housing for people who have don't have very good jobs. Let's put it that way. They're the people who you see facing you when you go into a retail store, particularly a chain store, and the people are on the other side of the counter. And there's a need for housing of people who are in the service trades. And some of them might qualify for low, some of them might qualify for moderate. I keep imagining.
Mr. Chair, you're fading.
I'm fading, sorry. Thanks, John. I paid $65 a month rent when I got out of school in Cambridge for an apartment that I imagine, if it still exists, is renting for more than $1,000 a month today. And it was very tiny. It was a micro apartment before that was named. But I think there are a lot of people who would like to live in the city, a lot of children of people who have grown up in the city who'd like to stay. And I think that this is important. And they aren't necessarily, the families with 3 kids. There are a lot of individuals who are just getting starting out. So, I don't know. John said I'm wandering. Other comments on this subject?
My only comment is that what I'm taking as the applicant's acquiescence to this concept and to this mix. It's got an impact on me as a board member in terms of the commitment to bestowing some benefits on the community. And I think it's a good direction for this project and for our approach in general in projects such as this.
Well, in the chart of criteria, one of the items is affordable units exceeding zoning requirements, targeting units for middle-income family. There's a comment in there. It's 2 separate ideas. I would very much like to proceed that way. Are you agreeable to that? They are. So we make that a condition or a finding that we base that thing on. The last item in the urban design objectives list is enhancement and expansion of open space amenities. We're looking for publicly beneficial open space in large parcel commercial developments. I think they're proposing to do that on Spring Street. It's coming along. There probably is a more design review that's needed. But I think they've allocated a good chunk of space that they're going along in that. One of the bullets is providing a wider range of activities. And I think that's one of the focuses of their design of that particular space. It's not just a place to look at and maybe let your dog walk on, but it's focused on activities. Are there other? That's one of the problems of this building is there aren't very many opportunities for open space, and like some of the rooftops of on the podium are pretty impacted by wind and are very desirable places for a lot of activity. Also, they overlook the residential to some extent.
Mr. Chair, complementing, existing pedestrian bicycle networks can also be a matter of the proponent being asked to put wayfinding signs up that could connect people to trails or point their way to trails. And I think that's some advice that staff could certainly give them as well. And they'd be meeting that criteria as well.
Now the question is, how do we wish to deal with the ECAP's guidelines? And I would propose that we might just look through them and see if there's anything that we've missed. The staff comments that the guidelines and ECAPs and the project review things are overlap a lot and the reason for that is that we have a comprehensive policy plan for the city that both documents are basically consistent and taken from. Okay, so we're going to take a 5-minute break and come back and look at those and do whatever else we have to do in a break. And we'll come back at, let's see. It's,
10 o'clock is stop.
right, it's absolutely correct twice a day. A few more things we have to do. We have to look through the East Cambridge guidelines and see if there are things that do we need to comment on, or no, I don't have many red marks in my own draft. We've got to discuss the request for a special permit for parking greater than 300 feet from the building. And then Jeff has been keeping track of what we've been doing, and we'll have some reminders about things that we may have to also address before we can take a vote. So on the these ECAPS design guidelines, there's language in the design guidelines about the kinds of active retail uses. That's on page 10 of 13. To the extent that the decision addresses desired retail uses, that's the list that would be included. Services for the public, daycare centers, community spaces, some of which are already in the plan. Ironically, the building, existing building meets one of the CAPS guidelines. It just shows the danger of reading guidelines out of context. That is to say, there is a cornice line at less than 65 feet, and the rest of the building that's taller is set back from that. And it does do that. We're glad that it does that because it will be effective for the pedestrians on the street level. There's a thing about expressing bay widths, and in particular the retail elevations are expressing the column grid of the building, which is in bays that are about that size. There great attention has been given to cornices, other details, and the new design for the tower is articulated to avoid the previous monolithic appearance. Talked about that. Trying to edit out I don't mind the repetitive things. I think we mentioned the acoustic report about the screening of rooftop mechanical. They located the vehicular parking access at the least and the most commercial side of the building. I'm assuming that bike racks proposed along the street, although I can't remember seeing them on the plan, but that should be, I'm sure that will be part of the plan.
The hubway is shown on the plan.
Hubway is shown, but the bike racks in the public domain along the sidewalks now. They're springing up everywhere. It's really nice for us bicycle riders to find these racks showing up all over the city. And is there any other comments on the ECAP's design guidelines?
Only one, Mr. Chair, and that is for public realm transportation. There's a bullet that says preserve rights of way for future urban ring project. That's really the only thing that I saw here that we haven't talked about. All right.
Right, and the urban ring would not, I mean, there are various phases of the urban ring, there are bus phases there, but I don't believe any of them are proposed to be adjacent to this person.
I just want to make one comment environmentally. In irony, we've been dancing around the question of preservation because that's what, in fact, is going to happen here. The superstructure of this building will be preserved and reused and reused. And as difficult as that is to imagine, it actually saves an enormous amount of embodied energy environmentally. It's the correct thing to do in a world with now increasingly understanding that we have finite resources. The reuse of the structural frame actually is the responsible thing to do environmentally. There is a condition on the built form of the environment in the East Cambridge guidelines asking for conservation and efficiency in construction and resources. And ironically, this actually is a very significant green strategy in terms of the conservation of those resources.
The one comment I'd make is with regard to open space. In my listing of the summary of traffic and transportation mitigation earlier, I neglected to mention the new park that the proponent has agreed to create on 2nd Street, not just the space on their own block on Spring Street, but also they agreed in their traffic mitigation to do a park on 2nd.
Where did the setback between the garage and the street?
Right, exactly, and that's an important contribution to the open space that both should go into, I think, in here and into that list of transportation mitigation measures.
Then there's a request that came in the revised submittal in July for a special permit to allow commercial parking to be more than 300 feet, but not more than 1,000 feet away from the site. And the reason this is requested is that although they want to park in the city parking garage and they've started to try to make that happen, it's a discretionary action by the city council, and they can't know whether it's going to happen until it happens. Yet they need, under the planning board permit, they need to have the 512 parking spaces. So, in the event that the council finds that that city garage cannot be used for this purpose, or maybe it's not used for this purpose any longer, since one of the reasons the garage is there is to serve this building and others. Or if they find that there aren't sufficient spaces in the First Street garage that they're willing to lease, the fallback is to seek other parking spaces, other places they want a special.
Sorry, other parking spaces.
And other locations within the 300 to 1,000 foot distance. And so they're requesting this permit in the hopes they won't have to use it.
I think we need to be clear too about what the planning board's desire desirable outcome might be. This planning board member feels that the closer parking garage and the solution in the city garage is the preferable one. It makes much more planning sense to have the cars closer to me, and the extent to which that might be supporting the retail ambitions of the project. I think I want to go on record and try to communicate that pretty directly to the city council. This is something we'd like to see, but understand the real politic of the situation, and we want every attempt for this to get done and completed. But the proponent, I think, needs the flexibility for real reasons to get the project moving, to have this other special permit in his back pocket.
Mr. Chair, at the risk of sinking a little bit out of tune on this subject, I certainly echo what Tom said, but I would echo it perhaps on steroids. I think from a planning perspective, it's very important that the parking be in the city garage, and I know the applicant feels the same way. But again, in terms of benefits and deficits, detriments to the neighborhood, I think that the commitment to not only create the park that Catherine just mentioned, but more importantly, the grocery store in the first floor of that garage is a really important benefit for the neighborhood. And again, as for me anyway, as I balance the pros and cons here, the opportunity to deliver that grocery store to the neighborhood is an important consideration. So my inclination actually is to not grant that special permit and put a special pressure on the city council and on the developer to reach an agreement on leasing that city garage. And I mean, it holds both of their feet to the fire, but and it puts pressure on. I'm not sure how that will play out and whose interest that ends up serving, but our interest is to assure that that lease agreement is reached. And I'm not inclined to offer an easy out, an easy escape valve to the Galleria. So
I'm sorry if I might have mischaracterized the way I thought the back pocket special permit. That's not what I meant. I'm aware of, and I think we all are, the effect that this might have on the actual project to move forward, right? If they can't secure the parking, legal parking, they're not going to secure financing, and this thing will remain the hulk that it is that we're, at least this board member, is trying to avoid in that neighborhood, and it's a big risk.
No, I'm with you, Tom, and I guess I didn't finish my thought. I neglected to finish my thought, which was the corollary to all of that after a period of time, and maybe it's one which we define, or maybe the applicant defines, they come back and say they were unable to reach an agreement with the city council, and we reconsider their request at that time. And
Can't go back for 2 years when something's been denied.
unless the applicant waives.
We can't hear what you're saying, Mr. Rafferty.
The repetitive petition requirements of Article 10 prohibit an applicant a petition being refiled within 2 years of an adverse finding.
Well, that kind of messes up my idea, doesn't it?
Mr. Chair? Steve, are you finished? Because I don't want to run over your comments.
If that's right, and it sounds like that's a serious consideration, then I picking up on Tom's original point, I would really somehow want to read into our decision a very strong preference, exhortation to the city council and the applicant somehow do what it takes to reach an agreement. And I'd really emphasize again the benefits of the grocery store in particular, and the park, and the proximity as strong arguments and justification for going that route.
Mr. Chairman and fellow board members, I believe that we should not prevent the proponent from doing the kinds of activities the proponent needs to do in order to push the project forward. And, however, I believe we need to make it very clear that if the City Council does not vote to allow this proponent to use the garage next door, that we will not see the astounding amenity of a fully developed grocery space that a grocery store is able to move into. So I believe that it's in the council's purview to make that happen or to not make that happen. And I think that we need to be real clear about that as well. But I don't want to hold this proponent back by not allowing the Galleria to be a use if in fact this proponent is not going to find a cooperative council.
So how do we cement the bona fide negotiation with the city council? Can we condition the special permit to exceed the distance from the site by saying that the city council has to deny the request at the city garage? Then and only then would the special permit to go to exceed the 300 feet kick in. So to try to put some teeth into the fact that we want a bona fide negotiation with some urgency and some energy with city council.
Makes sense. Granting with a condition.
I support the idea that that's a really important part of this discussion. However, I also want to be careful that the grocery store is not a part of what's before us right now. It's not a part of this proposal. And so we shouldn't be considering some future grocery store that may or may not occur in determining the impacts of this project. And so we should be clear that that's not one of the criteria for this, or it is not because of that grocery store that we think this project meets its criteria. I'm a little hesitant to create a condition that the applicant has to fulfill, that they have that they don't have the ability to solely determine whether or not they can achieve. And for instance, in the past, we have required applicants to work with Mass Highway to obtain approval for curb cuts and the like. And work with is the most we can condition that on, because at the end of the day, Mass Highway in that case determines whether or not that curb cut is issued. Similarly, I think it is appropriate here to say we want them to work with the council to reach an agreement, but the council has a complicated disposition process and frankly some discretion as to whether or not they go through it. So I don't even want to personally, I don't want to condition this on a denial, because the council could, think about it for the next 3 years, whether or not they're going to even start a disposition process. At some point, I think we have to make an assessment of whether or not the proponent has exhausted their options, and in order to move forward, needs that escape valve, if you will, to be able to use this space. And I think that the Galleria is a reasonable place to do that. I think that the marketability of the project is better if they can get the parking closer, and so the proponent has every incentive to make that happen if they can. But if they can't, they still want to use the building, and I'd rather that they use the building for something and have people park at the Galleria. And again, that's the people in the office tower who'd be parking at the Galleria. The residents, their parking is under the building regardless, and that's an important distinction. People walk as far from the Galleria as to the courthouse all the time to get from the T to their office building. That's not an unreasonable distance to walk. And I do think it's not feasible to say, we have to wait till the council denies a request for disposition here in order for them to move forward with that option. I think we have to say, they have that option or they don't. I would like to give them that option, knowing full well that they'd prefer to be in the First Street garage.
It's wonderful being on a board with three lawyers.
Well, I agree with what everybody said. I mean, I think the city garage is the logical place for the parking. And I agree that the Galleria garage is not an unreasonable place to have the parking. And I also agree that the grocery store in the city garage is not what is before us. However, I was very impressed by the number of comments we've received from the public of the importance of the grocery store to them and how that weighed heavily in a lot of people's minds in deciding whether they wanted to support or not support this project. I am concerned about giving some other board, even the city council, the power to effectuate or not effectuate the special permit. On the other hand, I don't think there's anything wrong with making it clear to them what our preference is and to put a little teeth into it. I think the proponent, if required, to use their best efforts to obtain the lease for the parking garage, which, as I understand it, is tied up with the lease of the grocery store space, but that if they cannot obtain it within a certain period of time or some other key to what would make it, that then the special permit for the Galleria garage would go into effect automatically. But I would like City Council to know this is what we think is the best use, but also that there be a requirement on the proponent to negotiate in good faith and for the City Council to negotiate in good faith. I don't want either side to feel, that somehow they've got the upper hand, but that, this is what we see is the better of the two proposals.
Just saying, a footnote I think Ms. Larson confirming what has been said, but I don't think in the end of the day that we really need to incentivize the proponent to execute a lease in the city garage. I think it's clearly in their interest to do so. It's really the city council that we have to urge to do that, and I think the city council's calculus on this one is actually much more complicated. Let me also say, though, Catherine raised a good point, because I don't recall hearing in our public hearings all that much talk about the grocery store. I don't know if commitments have been made with regard to the grocery store, and I'd love to see a commitment that if you are successful in obtaining a lease for the city garage, that it will in fact be a grocery store in the garage, because as you alluded to, a lot of folks would be kind of disappointed and feel misled if it weren't to be a grocery store.
Mr. Chair, if I could address that factually.
Yes.
Contained in the record of this file is the request that was submitted to the city by the proponent, forwarded by the city manager to the city council, to lease ground floor space for a grocery store as well as the parking spaces. And that the initiated disposition process was approved nothing in the fall of last year. Since that time, little has happened on the city council side. I think the message has been that until this process is concluded, there doesn't seem to be much appetite on the part of the council to engage on this. So depending on where things conclude and when they conclude here. It's certainly the applicant's position to continue on, but the request that's already been filed and in the record is for both spaces, ground floor as well as the parking spaces.
So given the opportunity, if you are able to lease space at the garage, in that scenario, it would be your intention, desire, commitment to include a grocery store?
No question. The only reason we filed under 6.22.2 was to provide the alternative. And our hope would be that the planning board would be guided by the criteria of 6.22, which frankly suggests that if the location is within 1,000 feet, safe and convenient pedestrian access, the permit shall be granted. It seems to me that the proposed location at the Galleria Mall meets that criteria, and the special permit is worthy of being issued.
Well, on reflection, I think it's probably right to grant the special permit, for sure. I'm not sure that we need to craft a complicated condition. I think it's important that the record reflect this discussion and reflect the board's strong preference that the city council work in good faith and as effectively as possible with the applicant to finalize a lease, not only for the parking but for the grocery store.
Okay. So, then I just want to find the specific findings that we need to make to that permit. And right here, in front of me somewhere.
What article are you in, Mr. Chair?
6.22.2.
All right, 6.22.2 states the Board of Zoning Appeal, in this case it would be us, may grant a special permit for off-site accessory parking not allowed in section 6.22.1, provided that the convenient and safe access from the from the parking facility, the use being served is provided in accordance with the following conditions. A, no off-site accessory parking facility may be located on a lot which is a more restrictive zoning classification. And B, off-site accessory parking facility shall be located within 400 feet of the lot being served for residential uses and within 1,000 feet of the lot for other uses. So the residential uses are served in the building, and so we're talking about within 1,000 feet for the rest of the use of the building.
So we're comfortable in making those specific findings.
I am, yeah.
Yes.
So, Jeff, what have we forgotten to do?
Well, the general.
I'm not sure how it is going to work. It's got a red light, so I'm not sure how long this is going to last. There's one point on this last question about the parking. It's because the parking is provided off-site and it's on, whether it's at the municipal garage or the Galleria, on a site that is not within the control of the proponent, there is a piece of the zoning which says that it will be allowed if binding commitments shall exist to guarantee to the reasonable satisfaction of the superintendent of buildings or to the special permit granting authority that the off-site parking will continue to be available for the period during which the use or uses that the parking served may be expected to be in existence. Such commitment shall be evidenced by negotiated lease agreement, recorded covenant, or comparable legal instrument. So that's because in this case that has not been produced, it would have to be a condition of the special permit that such documentation is produced, either in the case of the agreement for the municipal garage or another site as permitted under by granting that special permit in order to meet the zoning. So that's sort of a technical point, but something that the board should have on the record, that a lease agreement to use those parking spaces, a long-term lease agreement, would be satisfactory to meet in the board's opinion, to meet the zoning requirements.
This way that would have to be furnished before an occupancy permit could be issued. An occupancy permit was granted.
I would want to check with the superintendent of buildings. It may be that they would want that before a building permit, so that progress doesn't proceed and then they find that the parking actually doesn't exist after the construction is commenced.
I imagine you're going to borrow some money to do this. This is the kind of thing lenders focus on. We haven't gone through the 1043 criteria, and criteria A appears the requirements of the ordinance. This is all written in the negative. It's pretty annoying. Special permits will normally be granted where specific provisions of the ordinance are met, except where particulars of location or use not generally true of the district where the use is permitted in it would cause granting of such a permit to be in the detriment of public interest because A, it appears that the requirements of the ordinance cannot or will not be met. We believe that the requirements of the ordinance can be met.
And will be.
Traffic generated or patterns of access or egress would cause congestion, hazard, or substantial change in established neighborhood character. So this is a traffic condition, and it's about changing established neighborhood character.
And we're making a finding that this will not change the existing patterns of access or the existing congestion or established neighborhood.
Right, in part because the traffic is accessing, or substantial portion of traffic is accessing First Street.
Correct.
Which is outside the residential portion of East Cambridge. Although increasingly people are. The continued operation of the development of adjacent uses as permitted in the zoning ordinance would be adversely affected by the nature of the proposed use. Or that nuisance or hazard would be created to the detriment of health, safety, welfare of the proposed use and citizens of the city. Or for other reasons, the proposed use would impair the integrity of the district or adjoining district or otherwise derogate from the intent and purpose of this ordinance.
So here we're finding that the continued operation and development of adjacent uses are not being adversely affected by the nature of the proposed use, in large part because the proposed use essentially already exists. That it's not creating a nuisance or hazard to the detriment of the health, safety, or welfare, again, because it already exists.
And because of the oversight applied by the state for the remediation process.
Correct. And I think for the multitude of reasons we talked about, ameliorating the health, safety, and welfare of the occupants around, that even though it's not getting a lot better, it is getting better. And for other reasons, it does not impair the integrity of the district because it's already in the district.
And the final point is,
Final point is,
it's not inconsistent with the urban design guidelines.
it's not inconsistent with the urban design guidelines, which we have at some length gone through. Jeff, is there anything else?
Mr. Chair, there's nothing else on findings, but if you wanted to proceed, I've made a few notes to circle back on some of the items that were pointed out as potential conditions for the board to consider. I can kind of run through a list of those and could talk about it in more detail. There are some pieces that may require a bit more discussion and clarification. So one is the conditions in the traffic, parking, and transportation memo, which I think the board said were laid out in detail. Continuing design review on the loading area on 2nd Street, which is something that can be handled as it is normally through the course of continuing review by staff. The lighting plan, review of both interior and exterior lighting would be a component that would be subject to continuing staff review with you could clarify the language, but really with the intent of minimizing to the greatest extent possible impacts on adjacent properties. Was a comment about wind impacts, and that it would require more discussion with staff and possibly professional consultants to ensure that every reasonable thing has been done, and that measures have been employed to mitigate that to the greatest extent possible, feasible. As part of the construction management of the project, that there be possibly a committee similar to some committees that have been employed for city projects to provide ongoing oversight and monitoring and advice. I think in terms of structuring that, just as a general point when we do these decisions, it's often helpful to frame those as requirements that the proponent would need to undertake, rather than making it the city's responsibility to form a committee. Generally, when for us on the staff as agents of the planning board, where we have power is really in the ability to review what the proponent is doing and to hold up their progress if they're not doing exactly what they should, what they're required to do. So putting a condition that says, for instance, that the proponent is required to conduct public outreach, including setting up a website, establishing some kind of advisory committee, engaging with community residents, and then and providing evidence that that's been done at different appropriate steps throughout the process is one way that kind of a condition could be handled.
I would think step one would be coming up with a specific plan that would be reviewed with the staff and approved. And that could address some of the questions we had about how it's going to work.
And there's a similar point on the question about retail and retail marketing. It's been the case in the past that there have been conditions of special permits similar to continuing design review that call for continuing staff review of retail marketing and tenanting plans. That is something, because it tends to happen later in the process, that could be done. And similarly, there could be requirements to engage in some neighborhood or community outreach prior to the process of marketing those spaces to tenants. That was what I heard as being a concern to the planning board.
Yes, I agree.
So on the next page, I think, is the point about housing and the proposal that the board members put forward as a condition is pursuant to the urban design finding, looking for affordable housing above and beyond the requirements of the inclusionary housing, is to require 1/3 affordable units, 1/3, and just to clarify, I think that the board intended to say middle income units. Sometimes the term moderate income and middle income sometimes get interchanged, but they actually have different meanings. Moderate income is covered within affordable, the definition of affordable units, because it's up to 80% of area-wide median income. The term middle income is what refers to units priced between 80% and 120% of area median income. And that's the definition that's included in, for instance, the Alexandria zoning, which has a requirement for middle income, and also in some of the Kendall Square recommendations. So again, that's a clarification, but in terms of the overall ratio.
We're not to say we agree that it should be middle.
Okay. And there was a question about, there was a point about continuing design, further design review of the open space on Spring Street. And I mentioned the point about the condition requiring that the evidence be provided of the lease of the park. And I guess to clarify the conclusion of the board on granting the special permit for parking more than 300 feet but within 1,000 feet, would there be any condition attached to that? That there be some ways that it could be approached would be to put a time period, to say only after some time period is elapsed, or to say that the proponent would come back to the planning board within the scope of the special permit, would come back to the planning board for just a written determination that the best efforts have been made and exhausted to secure the parking within the 300-foot radius of the city garage prior to approval. So it's not entirely clear from, I know we just had this discussion, but it's not entirely clear from what the conclusion was.
I think your second point makes sense because...
Can you use the microphone, please?
I thought the second point makes sense, that the proponent would come back to demonstrate their best efforts, because if it becomes clear, say in a very short period of time, that the city council is not going to lease them the parking spaces, I don't see any reason for them to have to wait till a designated time period had expired. But not strong feelings.
I will defer to my colleague, because I think we're going to say the same thing.
Yeah, I don't think we should be putting any condition on this. I think we need to admonish the city council that we think it is a preferable solution, but ultimately that's their call, and they meet the criteria for the special permit, and we should grant it.
They meet the criteria because it's within 1,000 feet. Both.
And they're correct, and there's safe pedestrian access.
Right.
Therefore they meet the criteria as it is.
So the proponent proceeds to whatever outcome is best.
Correct.
Yeah.
And again, we think that,
Yes.
that the preferred outcome is the First Street garage, and we have every reason to believe that they will seek that earnestly, but I don't think we're putting a condition on.
Okay, next.
That was what I had on my list. So I guess the question then is there anything additional that should be, that's just a recap of what the planning board has discussed so far. So is there anything additional that should be considered in writing a drafting decision?
I had just one small point, Jeff, and maybe it's covered by your continuing overview, but there was a comment in the July memo that you had not yet received detailed drawings about the penthouse mechanicals. and that was going to require further information and oversight. So I don't know whether you need that as a condition or whether that just falls within your general, finalization of the plans.
It does fall within continuing design review, but it's helpful for the board to put that on the record and to have that written in the decision so that we have a very clear basis if we need to tell them, that they need to do more work on something, and it's clearly articulated in the decision.
Okay, I see the other members of the board are agreeing.
Yes. Mr. Chair, Jeff, is it a matter of course that there would be some degree of ongoing design review?
Yes.
Review of materials and other details and maybe a
Yes.
wall section constructed and so forth.
Yes, that's a condition that's attached to basically all permits, so that the department has to sign off before a building permit can be issued, and we need to go through that process to be able to make sure that the conditions and the representations have been made as the details worked out.
And to add just a little bit of clarity to that goes to the point, there are sort of two types of that continuing design review. One, the type of review we do, one level is to make sure that what is being proposed in the construction drawings for a building permit are consistent with what the planning board has seen and approved, just to do that certification. And then another level is where the planning board has made specific note of issues where the proponent should try to make improvements through the detailed design. Then we would, the staff would use their judgment to see that those conditions have been met and those improvements have been achieved.
Again, just to confirm my understanding, just for the example, the masonry of the exterior. I'm sorry. Just as an example for materials, I mean, the masonry is we've approved a look and a concept. We haven't approved a specific specification for the masonry or any other detail. Is that something that staff actually does review and approve? Yes.
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 And occasionally, from time to time, the staff brings things back to us where they feel they want our advice about such matters. So I guess the next.
I have a question. I'm unclear on the concept of what the condition is going to be with regard to the wind. And
With regard to
the wind, and most especially, if there is a consultant and some changes are discussed which are going to change the design or the facade, is that going to come back to us? I just don't know where that is really going.
I think that's probably a question for the board maybe to explore a little bit of what is the range or the parameters of the improvements that the board might expect to see.
Mr. Chair. I think that we have that content depth on the staff, and I would prefer that the staff make those reviews and that we have confidence in their skills and abilities.
Agreed.
Or if we don't have that content depth, we have the ability to hire that.
Purchase it. Yes.
Yeah, so I have some considerable experience dealing with wind mitigation. It's incredibly complicated. You fix one point where you've got to problem and it creates another problem somewhere else. And that's the nature of that. And it does take some expertise to rebut, actually, the consultant that was here, I happen to know, is considered one of North America's premier consultants. You'd need somebody to go head to head with him to double check it. And you know, with all due respect to the amazing staff here, it may need somebody from, I don't know, MIT to figure it out. So I think we should anticipate that we get expertise. Or encourage them to get expertise to rebut that. I don't know how to define the standards exactly for what we're expecting. I would leave it up to the experts to haggle that and figure that out.
Well, I guess my question goes to, let's say we get this expert and ultimately they conclude that the wind breezaways they have on the roof and at the cornice line should be removed. Does something like that come back to us, or is that just, you know, staff going to say, okay, this is the best way to handle it?
And Stuart Nash. And in general, as Jeff described, the staff reviews these kinds of things, and if there's any question that something is above beyond a clear staff level decision, then we bring it back to the planning board.
What I'd simply add to that as well as I think Tom indicated, this is something that would probably require additional outside expertise to do this. And you know, it would seem to me that it would not be inappropriate for the planning board to suggest that the cost of that outside consultant be paid for by the petitioner, but that it would be someone who would be reporting to the CDD.
That's the way it's usually done. At least in my experience as an architect on the other side of the table, if it's something that's so complicated it requires experts to conceptualize and experts to review, the burden of paying both experts falls on the petitioner. The reason I think this is important is simply because I don't know enough about this, and Tom knows more than I do, says it's really complicated, and it's, you know, it's science, but it's also art. And so we know we've got a building mass that's got problems. We know that the petitioner has used good faith efforts to study it, but this is a case where we think we should go one more step. And but what that's going to happen in that discussion, whenever I've been involved in the dueling expert process, the experts behave professionally, they discuss the substance of the problem, and they work out what they believe is the proper solution together so they can each tell their clients that this is the right solution. So the selection of that person is important.
The selection of that as well.
Pardon? The selection of that person is important, and that they get somebody who can talk at the same level as the primary consultant. As an example, in the TUMI process, the question came up about the cost of remediation, and an expert was found to engage that topic and reassure people that the numbers that were being sent on that were reasonable numbers, and I think that's sort of what we want. When somebody can say, "Yeah, that's reasonable. You can do that. Will have some effect." And there isn't some missing piece that these very talented people have somehow missed in this project. Mr. Rafferty?
Mr. Chair, just for an understanding on the applicant's part, is it fair to say this would be a form of peer review?
Yeah.
Rather than, they may not be dueling or conflicting experts, they may actually work collaboratively. I just hate to set it up as an adversarial process.
Right, I think when this process works best, it's a peer review.
Right.
And I think that's a good way to characterize it in the definition. I feel moved to make some remarks before we move to a vote. We basically had 2 points of view that we've heard from the public. And one point of view is that they would like to see something done about this horrible building. And they would like us to make sure that we get the best possible deal for the city and for the neighborhood. And in making that happen. The other point of view is that this is outrageous and unconscionable that the state is behaving this way, using this building, and not recognizing that should have been a better process.
Indeed.
And those are kind of the two, and I'm trying in a sentence or two to characterize a very complicated subject, but those are the two approaches. And so I started out in the first camp when we first started talking about this, looking and saying, they've made a bunch of significant improvements. And then I sort of moved into the second camp, saying, but why do we really have to accept this? In the ideal world, not governed by state disposition agreements and legislation that tells the state how they have to deal with their assets when they dispose of them. It should have happened better. In my view, the state should have said, okay, we're going to step up to the plate and fix this problem before we send it out to bid. But that's not what the disposition law in the state says. And so, and then started listening to a lot of testimony. A lot of people have felt that it was more important, it was really critically important to move forward and get the best possible outcome, given that the building seems to have the legal right to continue to exist. That may be challenged by people who think that that's not correct legal interpretation. We've not addressed it in our discussions because our approach has been to ask the city solicitor to give us guidance, and we're following that guidance. I would be surprised if this doesn't get discussed. This question gets discussed in court, no matter what decision we make. But I think I'm comfortable now with moving forward, and I'm pleased to think that tonight we've identified a lot of little pieces, little additional pieces that will make this building, this project, a better neighbor. So that's sort of my journey through this discussion. I don't know if anyone else wants to make any remarks or want to make a motion.
Well, I prepared it, but 40 minutes of remarks. I wanted to reflect on this, oddly, as intractable as this may seem to some people, I think this has been a very good planning process. We've got great input, both pro and con, from the community. We've got a proponent here who reacted, changed the submission, changed the design significantly as a result of those conversations we've had tonight. I'm really proud of the deliberations. I'm a planning geek too, Hugh. I thought it was fun. That's really all I wanted to say. I don't know, maybe others want to make some comments before we frame the final motion here, but planning's, we deal in an imperfect world, and we're trying to do the very best we can, and that's all I can reassure people here who perhaps might hold the opposite view about how I'm going to vote right now in a moment or two, that we're just doing absolutely the best we can for the city that we love profoundly. So, and we share that with people who have both the pro and the con view.
I would only one thing. Certainly, we wish the process had been different. Certainly, if we were reviewing the building from scratch, we would not have approved such a tall building. But having said all that, I do want to say I think we've ended up with a very handsome building. And in particular, the way the building meets the ground, meets the street, meets the neighborhood, I think it is a dramatic, radical improvement over what we have right now. And the 4-story residential portion, actually, as you live and walk in the neighborhood, that's primarily what you're going to see. And I think it is actually going to feel in scale. I know that there are a lot of people that are highly skeptical of this building, and I hope and believe that if the building is built as drawn and as presented to us, I hope and believe that a lot of folks will come to find and believe that it's actually a more than tolerable but a very handsome addition to the neighborhood, which will stimulate business in the neighborhood, restaurants, and will be a net plus for the neighborhood and for the city in general. So I did want to acknowledge that the quality of the design, as well as what I believe is a good quality process.
I just want to take a minute to appreciate the tone everyone has taken through this whole process, both pro and con, the proponents, all the experts, this board. This has been a really big deal for the whole city, and in a lot of other situations could have become very heated and very divisive. And one of the things I've really been struck by in hearing comments from neighbors, in hearing discussions between neighbors who had opposing points of view, and certainly in hearing the discussion among the board and with the proponents, is the thoughtfulness and the respectful tone that everyone has taken. And I hope people feel like they've been heard. I certainly feel like the board has really taken its time to hear all the points of view and to go through all of the impacts that this building will continue to have on the neighborhood, and figure out the best way to package this so that it addresses as many of the concerns that the neighbors expressed as we can, given the status that the city solicitor has advised us that the building has. And I really appreciate that everyone has been so respectful in their tone, that it's really made the process a lot smoother and more enjoyable to be a part of, and made our job a little easier to walk through.
Well, I definitely echo everybody's comments, and especially Catherine's, because it has been an exciting process. I mean, I think when I first saw it, I didn't know what I thought or where I'd come out. And it's been many months of going through plans and through hearings and lots of public input, and it's really just been terrific. And we received a comment today that I thought was really the most important. It was a reference to us that whatever we decide, there may be litigation one way or the other, and that all we could do was to, vote for something that we were really, each of us individually, were really comfortable with and felt that we could justify to ourselves and be proud of ourselves and be proud of the process. And I thought that was a great comment. It acknowledges that there are two sides to pretty much every issue, and that there's not necessarily a right or a wrong, but that we just have to decide what we want to do and move forward with it.
So I believe it's time for a motion.
I would move that we grant a series of special permits to convert the existing non-conforming courthouse structure at 40 Thorndike Street to a mixed-use office building containing ground floor retail use, 24 dwelling units, and below-grade parking. That they would include a special permit under Section 19.20 Project Review, Section 8.22.2A, alteration of a non-conforming structure, Section 5.28.2, conversion of a non-residential structure to residential use, Section 6.22.2, allowing for off-street accessory parking within 1,000 feet, and pursuant to the general special permit requirements of 10.40, subject to the conditions that have been identified this evening and reiterated by staff, and subject to all the findings that this board has made this evening as we've gone through the various requirements for the special permit.
Did I just miss it, or I did not hear Article 19 mentioned in your list of special permits?
The first one.
Oh, thank you.
You can tell if Mr. Rafferty is still in his chair. The motion has the right form. Is there discussion on the motion? All those voting in favor of the motion? 6 members voting in favor, and the permits are granted.
Thank you very much.
Yes, sir.
Given the complexity of the decision that has to be written and the time constraints, the staff would ask the planning board if they would ask the applicant for an extension to the end of the month of October. Right now it's at October 15th. It would allow for
If they
adequate
don't do it, then they
review.
won't be able to comment on it.
Now that we know it's a favorable decision, the answer is yes. That's Mr. Robert Dickey on behalf. Am I wrong?
Yes.
Yeah.
Okay, so on the motion to extend the deadline, all those in favor?
Thank you.
Thank you.
Thank you all. Meeting is adjourned.